Good day, Mr. Hao. My name is Mo Yushen and I have been asked to explain your legal positions following the sale of Upton. I understand that legal document can often be difficult to follow, so I will explain everything as clearly and simply as possible. In these presentations, I will answer three important questions. First, do you have a right to remain living in the west wing of Upton after the sale of Regent Estate Limited? Second, does Ms. Amira Gray have a right to continue living in the east wing? Third, does the answer change depending on whether Upton is registered land or unregistered land? I will first go through the timeline so we can understand the background before moving into the legal issue. You have lived in the west wing of Upton since your birth in 1956. In 1985, your father, Sir William, tell you will always be home. You will never worry about leaving. After hearing this, you continue living there on the understanding that you will always be allowed to stay. In 1992, you spent around 80,000 repairing the roof and structural bits of the property. Later, in 2005, extension built and maintained the adjoining gardens. In 2020, Ms. Amira Gray moved into the east wing of Upton and began paying rent every month. In 2022, Sir William passed away and the property was inherited by Charlotte and Caroline. Finally, in 2025, the entire estate was sold to Regent Estate Limited. The first issue is whether the law recognizes any right in your favor over Upton. Even though your father was the legal owner, the law can still recognize rights arising from permissions and conduct over time. Of the most relevant principle here is probability extrovert. As established in Turner against Major, there are three key requirements: assurance, reliance, and detriment. The first issue is whether there was a sufficiency clear assurance. In 1985, your father told you, "This will always be your home. You need never worry about leaving." Although he did not expressly promise ownership of Upton, the statement was clear and intended to reassure you that you will always have a place there. This is similar to Turner against Major. In that case, Peter Thomas worked on his cousin David Frank for many years for little pay. David repeatedly made indirect statements and conduct suggesting that Peter would inherit the farm. The House of Lords held that although the assurance was not explicit, it was sufficiently clear in the circumstance. Like this, your father's statement would reasonably be understood as a promise that you could remain at Upton permanently. Similarly, in Gillett against Hall, a young man devoted his working life to helping Mr. Hall after repeated assurance that he would inherit property. The Court of Appeal held that the insurance credit and equity risk is always be unconscionable to Danny. The second requirement is reliance. After reaching your father's insurance, you remain at Upton for decades and treat it as your permanent home. The courts are often prepared to infer reliance where a present consistency and in accordance with the promise made. In Gracie against Cole, a housekeeper stayed with the family for many years because she had been assured that she would have a home for life. The court presumes reliance because she had organized her life around that assurance. Like this, your long-term commitment to Upton strongly indicates reliance. The third requirement is detriment. You spent approximately 80,000 on structural repair, financials, and attentions in 2005, and maintained the gardens for more than 30 years. These are substantial financial contributions and personal sacrifices. In Gillett against Hall, the claimant devoted his career and personal life to Mr. Hall's business, the following of other opportunities. The court recognized that detriment is not limited to financial loss and should be considered broadly. Similarly, your expenditure, labor, and commitment over many years amount to significant detriment. Therefore, it would be unconscionable to allow the promise to be withdrawn, and you have a strong claim based on probability as to birth. There is also a possible claim under a common intention constructive trust in Royce Bank plc against Rothschild. Rothbridge stated that a constructive trust arises when there is a common intention that the claimant should have a beneficial interest in the property, and detriment relies on that intention. In lawsuit itself, the wife supervisor's renovation staff made no direct financial contribution toward the purchase price, and the House of Horror refused to recognize a beneficial interest. By contrast, your case is much stronger. Your father's statement indicates a common intention that you would have some continuing interest in other ways. Furthermore, you spent $80,000 on repair, financials, and extensions, and maintained the property for many years. These acts go far beyond for occupations and demonstrate detrimental reliance. Accordingly, you are likely to possess an equitable beneficial interest in other way under a constructive trust, in addition to having a strong properly established claim. Under Section 3, Paragraph 2 of the Land Legislation Act 2002, an equitable interest may buy a purchaser if the claimant in actual occupations of the property. In William against James Bank and Bolton, Miss Bolton had contributed to the purchase price and remains in occupation of the matrimonial home. The House of Law held that her beneficial interest occupied with actual occupations constitute an overriding interest binding the bank. Although Edward was in hospital when Regent's estate inspected the property, his future and personal belongings remained in the West Wing. It was lost, and you intended to return. This suggests only a temporary access. In Choka against Choka, the wife was absent from the house because she was in hospital giving birth when the purchasers inspected. Yet her occupation was hard to continue because she intended to return. Similarly, in Link Vending Limited against Boston, a woman detained in a psychiatrist hospital remained in actual occupations because she intended to return and her belongings remained in the property. Therefore, Edward is likely still regarded as being an actual occupations. However, actual occupations alone does not guarantee protections. Under Section 2 and 27 of the Law of Property Act 1925, where the purchaser's money is paid to at least two trustees, the equitable interest is detached from the land and transferred to the proceeds of sale. In City of London Building Society against Fred, elderly parents contributed substantial to the purchase price and lived in the property. But because the mortgage money have been paid to two trustees, their beneficial interests were overreached. Consequently, despite their actual occupations, they could not accept liens against the mortgage. Like this, in State Bank of India against Sud, payment to two trustees was sufficient to overreach the equitable interest of beneficiaries. Since Cheryl and Caroline were joint legal owners and the purchase money was paid to both of them, the requirements for overreaching are satisfied. Therefore, Edward's liens are transferred to the sale proceeds and do not buy Regent estate. On the other hand, Edward may appear to have a right to remain in occupations under the doctrine of notice. In unregistered land, a purchaser is bound by equitable interest of which they have actual custody of or imposed notice. In Kingston Finance Co. Limited against Rija, the husband concealed his wife's occupations from the lender. But the lender inspector noticed evidence of her presence and failed to make adequate inquiries. The court held that the lender had constated notice and was therefore bound by her equitable interest. Similarly, Regent Estate assets of the West Wing was locked and that your furniture and belongings remained there, yet failed to investigate further. It may amount to constructive notice, allowing your interest to buy them. However, this position is overridden by the doctrine of overreaching. Since the purchase money was paid to two trustees, your equitable interests have been outraged. As a result, your interest is detached from the land and transferred to the sale process. Once overreaching occurs, the doctrine of notice no longer protects you, and you cannot accept any right to remain in occupation. In summary, although actual occupations in registered land and constating notice in unregistered land may initially protect our equitable interests, the doctrine of overreaching ultimately prevails. As advertised in City of London Building Society against Fred, payment of the purchase money to two trustees remove the equitable interest from the land and transfer it to the process of sale. Now, turning to Miss Amira Gray, she has occupied the East Wing since 2020 and pays rent every month. Under Street against Montfort, where a person enjoys exclusive possessions for a term of rent, the arrangement is generally regarded as a lease, rather than a mere license. In that case, although the agreement was labeled a license, the House of Lords held that the substances of the element prevail and recognized it as a lease. Here, Miss Gray occupies the East Wing exclusively and pays monthly rent. Therefore, she most likely has a legal periodic tenancy. If the land is registered, a legal lease granted for 7 years or less constitutes an overriding interest under Schedule 3, Paragraph 1 of the Land Regulations Act 2002. Accordingly, Regent Estate Limited take the property subject to Miss Gray tenancy. If the land is unregistered, legal estates automatically buy purchases without the need for registration. Consequently, Miss Gray tenancy survives the self regardless of whether the land is registered or unregistered. Therefore, Miss Gray is entitled to remain in occupations of the East Wing and Regent Estate effectively step into the shoes of the previous landlord. To conclude, you have a strong equitable claim based on father care assurance and your long-term financial and personal contributions to other debate. However, if the land is registered, the doctrine of overreaching may mean your rights are transferred to the sale process rather than giving you a right to remain in the property. If the land is unregistered, your position is stronger because Regent Estate is likely to have an constated notice of your interests. As for Miss Amira Gray, she has a valid legal lease and she is entitled to remain in occupations of the East Wing despite the sale to Regent Estate Limited, regardless of whether Upton is registered land or unregistered. Overall, your rights depend heavily on the registration lectures of the land, whereas Miss Gray's position is legally protected in either scenario. Thank you, Mr. Howe. I hope this explanation has helped you understand your position clearly.